I'm attorney Phil Jusino, and this is WLNY's Finding Common Ground here on Altice. You can see this show every Saturday at 10 a.m. on channel 115 and Thursdays 1 a.m. for you insomniacs on channel 20. We have a great show planned for tonight. The theme of the evening is the New York State court system. We touch a little bit on the federal, but it's mostly the New York State court system. And these are courts that many of you will find yourselves in. Criminal, civil, traffic, lawsuits. You go for a small claims case that affects many of you. Many people sue their doctor or the doctor sues them. Those cases go to a court. You get a traffic ticket, you go to a specific court. You're in a car accident and you're suing somebody for a lot of money. That goes to a particular court. Oh, let me digress for a second. Finding Common Ground can also be seen on Facebook Live at 8 p.m. That's a little bit different type of show. That's a little more heavy on political. And when you see it on Facebook Live, you can like, share. You can see a lot of these shows after you see it live. I'm sorry, after you see the tape version, you can see it on YouTube as well. Subscribe to YouTube. You can see these shows when you go to the WLNY Internet Radio Facebook page. I'm sorry, the YouTube page. You can look for Altice shows, and that's what this is. So let's get to it. In New York State, you have a series of courts, just like at the federal level. It's funny, the other day I was in court, and I represented a wife, and the husband didn't have an attorney. So the support magistrate said to the man, "You need an attorney, go get one." He said, "I can represent myself." Her response was pretty comical, I thought. She says, "What's the highest court in the state of New York?" And he incorrectly stated the Supreme Court. Then she said, "What is the burden of proof with a violation?" All right. He said, I think he said beyond a reasonable doubt, which that's not the case. That's in the criminal case. And she asked him one more question. And this individual was a police officer. So clearly he wasn't up to date on all the court systems. He probably knew the criminal courts pretty well, but he didn't know all of them. So I said to myself, let me educate my audience as to what the court system in New York happens to be, with a focus on Long Island. In New York, the highest court in the state is an appellate court called the Court of Appeals. All cases that are appealed in New York can end up there. Not all cases make it up to that court, but if they do, that is the law of the land. What do I mean by that? When the Court of Appeals makes a decision, all parts, all corners of New York State have to follow it. The Court of Appeals judges, or they're called justices, there are 7 of them, and they serve a 14-year term. Under that is what they call appellate courts, just like the Court of Appeals is an appellate court, that's the highest. The one below that, which I've been in many times, is called the appellate division. There are 4 departments, 1, 2, 3, and 4. First department, second, third, and fourth. It's broken up by region. So the first department happens to be Manhattan and the Bronx. The second department, that's Long Island. Long Island being Suffolk County, Nassau County, as well as Brooklyn, as well as Queens, Westchester, Putnam County, Staten Island, Orange County. Now, because there are 4 departments, believe it or not, there are differences in the law as interpreted by the appellate division in the 4 different departments. So the first department may have one way to look at it, and the second department has a different way to look at it. That's why when I do research and I try to find a case that I want to use in a New York State court, I always try to find a Court of Appeals case, or at least a second department case if I'm here on Long Island. Because if I find a third department case, which is upstate, the court can say, well, we really don't follow the third department. I want to see a second department case. But if you get a Court of Appeals case, that trumps it all. Okay, so let's jump to the trial parts, because these are the courts that most of you will appear before at some time in your life. If you're an attorney, you appear before them just about every day, like I do. So in New York, the question that was posed to that police officer in the case that I had, what is the highest court of the state of New York? He said the Supreme Court. Now, in the United States system, federal, The United States Supreme Court is the highest. But in New York, I said it's the Court of Appeals, Supreme Court is a trial court. It's not the highest. The Supreme Court of the state of New York is what they call unlimited jurisdiction. Technically, with one exception, it can handle all types of cases. But it doesn't. But if you sue somebody for $1 million or $1 billion, assuming it's not a federal case, you go to the Supreme Court. That has unlimited jurisdiction. They can handle criminal cases. They can handle all kinds of cases. The one case that it can't handle are cases against the state of New York. So if you're suing New York State, you don't go to Supreme Court. You go to the Court of Claims. That's just a trial court that handles cases where someone is suing the state of New York. Another type of trial court at that level would be surrogate's court. So if you're probating a will, guardianship, someone dies without a will, they call it administration, where a person dies intestate, that would be surrogate's court. Every county, there are 62 counties in New York State, every single county has a surrogate, one. And they handle all those types of cases. Probate, we said, if there's a will, has to be handled. That will go to the surrogate's court. A surrogate judge serves a 10-year term. To go back to Supreme Court for a second, a Supreme Court justice serves a 14-year term. They're elected. All of these judges, with few exceptions, are elected. Another court that people find themselves in very frequently, and I'm in there every day, I was there today, is family court. Those courts I mentioned, other than Supreme Court, limited jurisdiction. So in other words, you couldn't go to surrogate's court for a custody matter. You couldn't go to surrogate's court if you were in a car accident, you were suing somebody. That would be Supreme Court. All right? If you're suing the state, you go to Court of Claims. Family court is limited to family court type matters. Custody, parenting time, child support, maintenance, medical insurance, guardianship, adoptions, negligence. Let me give you a couple of examples. Someone wants to get custody of their kid. They go to family court. If they're not married. If they're married, they can go to Supreme as well. There's a division or a department of the Supreme Court that handles divorces. Family court doesn't handle divorces, but they handle issues that can also be handled in a divorce, like I just said, custody, child support, and so on. If you have a child support matter, you can go to family court. You want to adopt, you go to family court. So the limited jurisdiction is those types of cases. Orders of protection, I almost forgot that. If you have an order of protection involving family members, or boyfriend and girlfriend, husband and wife, people that have a kid in common, you can go to family court for that. The other types of cases below that would be district court. So in Suffolk County and Nassau County, which is unique, you don't see these district court type cases in other counties. They might exist, but for the most part, you don't see them in the city. You have city courts. Give you an example. Let's say you want to sue someone. And, before I forget, the jurisdiction for county court, that's another court, is $15,000. So if you want to sue somebody and you want to make it a little cheaper and quicker, you can go to county court, but you can't sue for more than $15,000. That you'd have to go to Supreme. So you got a case, 20 or 16,000, $1 million, Supreme Court. County court also handles criminal cases. So I'm in county court often, which are felonies, misdemeanors, and also violations. County court can handle them. Generally, county court only handles the felonies because misdemeanors and violations will generally go to district court, which the 5 western towns have district courts that can handle civil, small claims, criminal, misdemeanors and violations, lawsuits, things like that. Traffic as well. And the eastern towns have like towns and village courts. You also see some village courts and town courts in the western towns, like Lake Grove. I'm in Lake Grove. Lake Grove has a village court. Low-level type cases. You get a traffic ticket, parking ticket, things like that. A violation of the town code, that can end up in a village court or justice court or town court. Riverhead has a justice court. So if you get arrested, you don't head over to CI, the CI District Court, which handles the district court cases for Suffolk County. I'm talking the DWIs, the assaults, things like that are not a felony, would be handled in district court, in CI. There are other district courts. Hauppauge has one, Ronkonkoma, 5th District, Patchogue, 6th District, Huntington, 2nd District. They can handle misdemeanor cases, but generally, if you get in trouble in one of the western towns, you end up in Central Islip. Unless it's a felony, that would be Riverhead. So another type we said would be village and town courts can handle also lawsuits, things like that. Low level, small, what I call small money types of cases. Like when you watch Judge Judy, if you wanted to have that kind of case, which is under $5,000 or up to $5,000, you would go to small claims, which is part of a district court or a town or justice court. Now, remember I said the highest court in New York State is the Court of Appeals? You also, in the federal system, where they handle federal cases involving federal law or constitutional cases, which could be a state case that has constitutional implications, that would go to the United States Supreme Court. That's the highest court. Would go, ultimately could end up at the United States. They have circuit courts lower than that. But the highest court in the land is the United States Supreme Court. We've all heard of the United States Supreme Court. There are 9 justices, 1 Chief Justice, and 8 Associate Justices. You've all heard of Ruth Bader Ginsburg, Kavanaugh, those kinds of judges or justices, they call them justices, sit on that court. Now, unlike the state system, you don't really see much politics at play that are obvious. Behind the scenes, I'm sure, there's plenty of politics. But the United States Supreme Court is very political because they're the final word. They're the law of the land. Like the Court of Appeals is the law of the land for New York State, other than constitutional cases. The United States Supreme Court is the law of the land when it comes to federal, in the United States, of course, federal and also constitutional issues. So let's say there's a state case, like a criminal case, let's say. Like you all heard, he didn't Mirandize me, a criminal case. Well, that came from a case called People v. Miranda, where Arizona, I think it was Arizona first, the state of Arizona v. Miranda. There was a person who was convicted of a crime, filed an appeal, and it made its way to the United States Supreme Court because there were constitutional issues. If it's just state issues, it would never get to the federal system. It would stay at the state system. But issues, a lot of criminal cases get to the United States Supreme Court. Freedom of speech, the Second Amendment. Think of the Constitution, Second Amendment, the Fifth Amendment. Those issues are federal. So they wouldn't be at the state system. They go to the federal system. Now, the reason why I said the Supreme Court gets political is because the President of the United States appoints justices as openings occur. So the last time that a Supreme Court justice retired, Kavanaugh was selected by the by the president, and he had to go to through a confirmation process, which was grueling. And then people came out of the woodworks. He sexually harassed me when he was in high school. He attacked me. And there was a big hearing because the Democrats didn't want him because they're afraid he's anti-abortion. And just like if it was a Democrat president, he might pick somebody that was pro-choice where the Republicans might not want that guy. There was Merrick Garland. They didn't even give him a vote, the Republicans. So when it's the president's turn to appoint, the other side is going to fight it. Because if you have enough people, they call it stacking the court. So let's say President Trump already appointed 2. Let's say Ruth Bader Ginsburg retires or passes away. Then there's an opening. So President Trump would appoint the next Supreme Court justice. He has to be confirmed by the Senate. So they could vote against it, and then you'd have to pick somebody else. So it's very important. If he gets 3, and then there are other conservative type judges, it could be 6-3 for the conservatives. So when cases come up there, like abortion, they will have the advantage. And it doesn't always go that way. Justice Roberts, okay, was appointed by a Republican. He didn't vote that way by Bush. He didn't vote that way when Obama's the Affordable Health Care Act came up, or they call it Obamacare. He ruled in favor of President Obama. Conservatives were not too happy about that. I've read many times where a president appoints somebody thinking, okay, he's a good conservative, or he's a good liberal, and it doesn't turn out that way. But the president gets to appoint them, the Senate has to confirm, and those 9 justices decide very, very important cases throughout history. We had Plessy v. Ferguson at one point, I think it was 1898, that said separate but equal. So they could say, oh, we're going to have a black hospital or a black school. That changed in 1954 with Brown versus the Board of Education, where the justices voted, I don't know what the vote was, it could have been 6-3, 7-2, they voted to say separate can never be equal. So within that same body, at one time they said you could have separate schools, then they said separate is never equal. So that shows you how a different makeup of the court can change the law of the land, or how they interpret a statute. Doesn't mean the law changed. They look at a statute that exists, or they look at the Constitution and say, that's against free speech, or that's allowed. Very, very important who those 9 justices are. Now, some of the people running for President of the United States on the Democrat side want to change the makeup of the court by saying that Republicans pick 5, Democrats pick 5, and then 5 are selected unanimously by those 10. So they want 15. The problem is when you do that, it mirrors more a legislative body than a court. It's supposed to be independent of the legislature. That's why in the Supreme Court of the United States, lifetime appointment. Ruth Bader Ginsburg was ill for a while, still may be ill, and is old, and maybe she doesn't work as hard as she used to. But until she retires or dies or is comatose, she can still sit. And she has a staff, of course. I went to Fordham Law, and one of my professors had been a Supreme Court justice's chief clerk. And often they write the decisions for the judges, just like at the state level. Some of these law clerks or law secretaries, they're called, they help the judge or they author the decision. The judge has to sign on to it, of course. But often when there are motions and things like that, the judges can't decide that many motions on their own. They have a staff. All Supreme Court justices, just like all judges, for the most part. There are exceptions. Like I know lower level, they might not have their own. Family court, sometimes they share a law secretary. But United States Supreme Court has a whole staff that assists them. So the United States Supreme Court is extremely important. That's why the battles happen there, very public battles. So like I said, I suspect if President Trump has the chance to appoint somebody else, the Democrats are going to try to keep that person off. And they might not win, but they might try, especially if, let's say, it's right near an election year. There's like an unwritten rule where they say you shouldn't appoint anybody in an election year because let the new president pick that. And the president might say, I'm not going to do that. I want to pick it. It's my call. I'm still in office. I'm not dead. I haven't been voted out of office or termed out of office. I want to pick. So that's what they do. And the Senate could drag it on and on and on, and if they have the numbers. If they don't have the numbers, that person is getting confirmed. So that's how it is in that system. What I want to do now is go over something I called frequently asked questions. Now, some of the questions that I'm going to go over involve litigation, and litigation involves courts. So when I do a question, I'm going to say what court it pertains to. So in other words, if I'm talking about custody, the first question happens to be, what do I do if I want custody of my child? That case would go to family court unless the parties are married and one of them files for divorce. Then the case would go to Supreme Court, matrimonial part. So that's a part that handles divorce cases within the Supreme Court. I said earlier, you cannot get a divorce in Supreme Court. I'm sorry, in family court. You get it in Supreme Court. So family court, if the parties are not married, or even if they are married, they could still file in family court, which might be the best way to go. Quicker, cheaper, the attorney for the child that's appointed, they generally wouldn't have to pay for. Where in Supreme Court, if you need an attorney for the child, it used to be called law guardian, I used to be one many, many years ago, they would have to be paid in Supreme Court by the parties in some proportion. So if the husband makes $100,000 and the wife makes 50, the husband's going to lay out 2/3 to 1/3. So if the judge says, I'm going to appoint an attorney, and the initial retainer, he sets it, or she sets it, $3,000. Husband writes a check for $2,000, wife writes a check for $1,000. And that attorney is appointed to represent the interests of the children. In family court, with some exceptions, the attorney for the child is appointed. When I say child, it could be for children. If there are 3 of them, that generally would be one for all 3, unless the kids differ in opinion, where they could say, okay, 2 kids want to live with dad, 2 kids want to live with mom. We need 2 sets of attorneys for the children. So that would be family court if there's no divorce. So what do you do if you want custody? Let's stick with family court. You would file a petition in family court in the county where you live. So if the kids are in Suffolk County, you would file in Suffolk County. Again, I'm not going to get into a deep discussion about it, but let's say mom lives in Suffolk County with the kids and dad lives in Putnam County. He files in Putnam. The case could come here to Suffolk because that's where the kids live. Right? Now, if, let's say, mom and dad and the kids live in Florida, and the mom takes the kids, and assuming there's no domestic violence, which could be an exception, she comes to New York with the kids. And then she, day one, files a petition in family court in Suffolk County. The father can make a motion or file in Florida to get the case back to Florida because the kids haven't lived here long enough. They would have to be here 6 months. There's a thing called the Uniform Child Custody Jurisdiction Act, which the judges would have to communicate but follow the law. If she hasn't been here 6 months, the case would generally go back to Florida. Again, there are exceptions. If she comes here and says, my husband was physically abusive and he beat me up in front of the kids, the court can say you don't have to go back to Florida. But that has to be established and proven in some respects. Sometimes I say, did you call the police a number of times in Florida? Was he arrested in Florida? Do you have witnesses that say dad was abusive? It could be mom was abusive and dad took the kids to come to New York. File a petition. You could have an attorney do it. You could come to someone like me, and we would sit down and discuss the case. I'd tell you what your options are, and I could file a petition on your behalf in Suffolk County Family Court, if you're in Suffolk. And then that petition would go at some point before a judge or a referee. They would appoint an attorney for the children, generally. Even if the kids are little, they could still do that. And at some point, there would either be a settlement or the case would proceed to trial. But to start the case with a petition. If it's a divorce in Supreme Court, then you start generally with a summons with notice or a summons and complaint. That's the difference. One is a petition, one is a summons and complaint. They're considered pleadings. You would allege, I've been the primary caregiver, and I want custody because it's in my kid's best interest that I have custody instead of the other parent. Same kind of thing in Supreme Court. Second question, what do I do if I get a letter from CPS? CPS is Child Protective Services. You don't want to get a letter from CPS. If you get a letter from CPS that says you're under investigation, that's generally the first letter. It's like a hello letter. You're under investigation, you're on our radar. what happens? When you get that letter, you don't have to do anything. Assuming you don't get dragged into family court, you can just sit back and wait. I get calls from people. I got a letter. I say, does it say indicated or unfounded, or does it say that they're investigating it? They'll say, oh, it just says investigating. I'll say, you don't have to do anything. They may be calling you to investigate, but you don't have to take any legal action. Within 60 days, generally, of that letter, could be sooner, could be a little longer, they have to come up with, it's almost like a verdict. I'll call it a verdict, even though they don't call it that. They're going to say a finding. Either it's indicated, meaning you're in trouble, and they found some credible evidence that you abused or neglected a child or children, or unfounded. If it says unfounded, it's like being found not guilty. You don't have to do anything. And you're never going to know who called you in. You're never going to know that. That's something that they're not supposed to tell you, and you're never going to know. I've been doing this a long time, and it's a no-no when someone says, well, CPS told me. No, they didn't. And if they did, they violated the law, because they don't want people fearful of calling CPS. If you call CPS, let's say your neighbor is beating his kid, and you call CPS, you don't want them to say, oh, your neighbor, Sally Jones, called, because then you might be getting a beating or get a phone call or a dirty look. Even though he may have a feeling it's you, they're never going to know. Once you get that indicated letter, though, you have to see an attorney. You have to fight it. If you don't fight it, it remains in effect, and you will be on the registry, Child Abuse and Maltreatment Registry, until your youngest child is 28 years old. They say 10 years past his 18th or her 18th birthday. 28 years old. So if you want to adopt, you can forget about it. If you work as a teacher with kids, you got a problem. I had a case where it was a construction worker, and he came to me because he ignored it. He said, I don't care. I'm not going to be going to, and he didn't see his kid anymore. He says, I'm not going to adopt. I'm not a teacher. I don't need to challenge it. Until they assigned him a construction job at a school, and they ran the names and backgrounds of everybody that was going to be working in the school during school hours. He was one of them. He couldn't take the job because he was on that registry. And they couldn't put him in that classroom or in the hallway or on the roof of that building with kids there. So he didn't get the job. He came to me, we fought it, and it was removed. Now, when you get a letter from CPS that says indicated, you can fight it, like I said, with a letter, and I've been very, very successful fighting these. Most of the time I prevail with a letter. If you don't, you get a fair hearing, not in the courthouse. You go, it's almost like an office where you go and they have judges that rotate, that come in, they're administrative law judges, they don't wear a robe, but they come in with a tape machine, and you show up there with your attorney or by yourself, and you can challenge it. Sometimes you can work out a deal, sometimes you can challenge it and prevail, sometimes you don't. Now, if it's serious enough, not only will CPS be on your case, but your case could end up in family court. So let's say somebody starves their child, or doesn't send their child to school for a long time, or beats their child. CPS could get a call from the school, and there's mandated reporters. When I was an assistant district attorney, I was a mandated reporter. I had a legal obligation to call them. So if my neighbor was, let's say, being abusive to their child, and I'm an assistant DA, I have to pick up the phone and call and say, CPS, I've witnessed domestic or some kind of violence or abuse or neglect of a child, and then they investigate. Again, they won't say, Phil Jusino made the call. If I'm just an average citizen, like I am now, I'm an attorney, but I'm not with, let's say, the county, or I'm not an assistant district attorney, or I'm not a family court judge, or I'm not a law guardian. I don't have to do anything. I would want to protect the child, and I would do what is appropriate, but I don't have to. Mandated reporters. So in addition to having CPS go after you, your case could be brought to family court. Now, if they're going to take your child away, They have to give you due process. So if something is bad enough where they say, we got to swoop in and take this child, or kids, they'll usually come in, serve you with a piece of paper that says, get to family court this afternoon or tomorrow. They could take your kids, the police can come with CPS and they take your kid, unless they could put the child with, let's say, I had cases where, Leander's Law, where the mother was driving drunk with a child in the car. They can say, we're going to give the child to the father. Ma'am, you have to find a hotel tonight. You can't be around that child. Or the father, they can do the same thing. Or if it's both parents abusing or neglecting, they could take the child, and if they can find a grandparent, they'd rather put the child with a relative than foster care or something like that. So family court, the case would come to family court. You get an attorney. You're better off getting an attorney, or you can have one appointed for you if you don't have the money. And the case would come before the judge, and you would make your case to get your kid back. Now, that doesn't end the case. That just decides whether you have your child while the case goes forward. And you may have to take a parenting class. You may have to take a drug treatment program, an alcohol treatment program, a whole bunch of different things you may have to do to be able to get your kid back or to keep your child. I've had cases where, let's say one of the parents has a drug problem or an alcohol problem, but the other parent is a safe, secure, responsible parent. A case I had that was similar, where they said to the mom, okay, you can be there with the child, but only when dad is there, or when somebody, what they call persons approved. So the mother, the mother-in-law, the aunt, the uncle, the brother, the sister. CPS says these people are okay. You cannot be alone with that child. So when the husband comes home from work, let's say 5 o'clock, she can be with the child and the father. If he goes to work and she's home, she can't be alone. So either the child will be taken to childcare, school, daycare, or let's say it's a small child, the grandmother could come over and be there, has to be there. Can't say, I'm going to go to the store and I'll be right back. No. If CPS is monitoring that situation and drives by and knocks on the door, and I've had this happen to clients, and mom is there who's supposed to be supervised, and she's there alone with the child, they might say, who's the supervisor? Oh, they ran to the deli. Not good enough. They could take that child and make it so that the mother can't even live at that house because she breached the agreement, is you can't be alone with the child. So CPS calls you, contact an attorney like myself. That's your best bet to get the information you need to decide how to fight it. Let's move on to the next question. Is my spouse entitled to my pension and 401k? Now, remember we said a divorce can't be done in family court? These are what they call equitable distribution issues. They have to go to Supreme Court. You can't go to family court. You can go to family court if you want child support, but if you want to divvy up a house, a 401k, a pension, an annuity, a car, a bank account, anything that's an asset, or you have an interest in an asset, you have to go to Supreme Court. So is, let's say, the wife entitled to her husband's pension, or is the husband entitled to the wife's pension, 401k, annuity, retirement benefits, retirement accounts? Absolutely. First, you have to decide what is the marital portion. So you look at when they got married, from that day forward. So let's say the husband's a cop and he was a cop before they got married, that's his separate property. Once he got married, if they got married on August 1st, 2010, up until the point that the divorce was filed, the wife would be entitled to that portion of the pension. You have to do it either with a rollover or a quadro, otherwise there could be tax consequences. So let's say there's a 401k. If the husband just writes a check for half the account and gives it to the wife, if he's able to do that, there's going to be a tax consequence to maybe both of them. So that would be, let's say, if it's an IRA, it could be rolled into, the wife goes to Charles Schwab, sets up an account, and the money goes into that account. She does not get hit with a tax consequence unless she withdraws it and let's say she withdraws it and she's not 62 and a half yet, pays taxes and a 10% penalty. So yes, they are entitled to their spouse's pension 401k, and that would be done, if it's a pension, certainly with a quadro, qualified domestic relations order. A company like Lexington or Troyan, they come in, they figure out what the wife's portion is, and it gets put in an order that a Supreme Court judge signs. Can't be done in family court. Supreme Court signs it, and the person, when the husband retires, the wife could start getting part of his pension. Sometimes with an annuity or 401k, you can get it right away, but again, a tax consequence. You're better off talking to an accountant before you pull out any money from a 401k or anything like that, especially if you don't know if you're old enough to do that, because there will be a penalty. And taxes. So if you take out $10,000 and you're 50, let's say, not only will you get hit with a penalty, but it's income. So if you take out $10,000, you're going to not only pay a penalty, but you're going to pay 10% on that money you pull out. And you pay, well, that's the penalty, I'm sorry. You pay income on it. So if you make $50,000 a year, and normally you pay $50,000 taxes based on $50,000. If you pull out $10,000, now you're going to pay taxes based on $60,000. Next question. When I go to family court concerning a child support matter, what financial documents do I need to bring with me? This is concerning child support. It could be maintenance. It could be add-ons, meaning extracurricular activities, school, college. It could be health insurance. These things can also be decided in family court. Now, if the parties are not married, forget maintenance. You can't get it. The other things I said, you can. But maintenance, the parties would have to be married. So you go to family court, and what do you need to bring? Now, usually, when you get served papers, they're going to give you a financial net worth statement to fill out. Sometimes it's a front and back, or sometimes it's a 3-page document, 4-page. Whatever you get, you have to fill it out. And you're going to get that notarized, and you're going to bring that with you to court, because the court's going to want to see your financial net worth statement. They're also going to want to see your most recent tax return with all W-2s, 1099s. So you bring that with you. If you, some guys, let's say, work in construction, and they've had 4 job sites they've been to, or 4 companies they've worked to within a particular union, you got to bring all of those W-2s and or 1099s. You also have to bring pay stubs and proof of what you, so if you're the wife and you're saying, he didn't pay my medical, well, for the kid's medical, you got to prove it. You got to bring that documentation. All right? Now, when I say the pay stubs, the reason why you bring the pay stubs, let's say you go to court and it's November of 2019, but, which hasn't happened yet, but you have a W-2 for 2018, but maybe your income went up. Maybe your income went down. How does the court know that? They look at your pay stub. It says year to date. So if it's November or December, it's great, because you know within a couple of weeks at the end of the year what this person made for the whole year. So if you're in December, you can extrapolate. So you can calculate for 11 months, this is what he made. We're going to add on another month, assuming that December doesn't radically change for the guy. Like, let's say he operates a plow. Well, December, if it snows, he could make a lot more money in that month, or less money if there's no overtime. All right? Or if the guy works the parks department, December might be slower than July and August, of course. But at least the court can get a good handle on what the guy makes. If it's January or February, pay stubs aren't going to be as critical, because you're not going to really extrapolate if it's January 15th. You're going to really look at, what did he make last year? And a leap of faith, he should make about the same. But you can't, what are you going to extrapolate? Based on 2 weeks? Although the pay stubs can be telling, if the person now makes more per hour. Let's say they got a raise for the new year, and last year they made 10 and now they're making 12. Well, you'll see that on a pay stub, so it might be useful. Those are the things you need to bring. If it's a violation, if the wife files a violation petition saying the husband didn't pay me, she has to prove it. Now, if it's paid through child support collection, piece of cake. They have a printout, Boom, he didn't pay those 3 weeks, he owes it to me. If she's alleging he didn't pay child care, the burden is going to be on her to prove what he didn't pay. Because he might not admit it. He might say, I don't know what she's talking about. All right, ma'am, what did he not pay? He didn't pay for July and August, and that's $2,000. But that's a violation. Next question. What is wasteful dissipation of a marital asset? In a divorce, the court will determine who gets what assets. If it's a house, it could be sold and split equally. If it's a pension, we just talked about that, how the judge can say there's a marital portion, the Majaskis formula, numerator, denominator, and that's what the wife gets. So that's what the husband gets. Or if it's a car, they can use Kelley Blue Book to determine what the asset is. If it's a business, you hire a forensic accountant or somebody that values businesses to determine what the business is actually worth. Wasteful dissipation is when one party says the other party wastefully dissipated an asset. Could be a bank account. I'll give you an example. Let's say the guy is a big gambler, and there was a $50,000 account with $50,000 in it, and this guy went to Vegas, and he blew it all, and he lost it. And he comes back home, and let's say a divorce starts out right away, or in the middle of a divorce, and the wife says, that money also belonged to me. That was a joint account. You wastefully dissipated $100,000. $50,000 of that was mine. If the court makes that determination of a wasteful dissipation claim that you've established by evidence, you prove that he took the money out and he went to Vegas, or he went to Atlantic City, or he bet on the Jets and he lost all that money. The court can say, okay, fella, write her a check for $50,000. Or she gets a credit along the line, somewhere along the line, for $50,000. Now, there are cases that are not as clear cut. Let's say the guy invests in a company and the company goes belly up. I owned stock one time in Washington Mutual. Right? That company went out of business. Right? That is not wasteful dissipation. Right? That would be Wells Fargo. That would be bad luck, a bad financial decision. Things happen. Companies go out of business. So the court might not say, oh, you lost $100,000, so therefore you got to give the wife $50,000. They might say, hey, look, you were the guy that made these financial decisions, and it just wasn't a good decision. Or you bought a piece of property that turned out to go down in value. Well, that sometimes happens. Okay. Next question. Do I need grounds for divorce? The answer is yes, but you go with 177 of the domestic relations law, which is irretrievable breakdown. That's enough. It's a very, very low bar. I don't like the other person. I want a divorce. It used to be we had to show cruel and inhuman treatment, adultery, actual abandonment, constructive abandonment, not anymore. So years ago, you sometimes had to have a trial. If one of the parties says, I was a good and dutiful wife, I don't want a divorce, and the husband says, but I do, well, you have to have grounds. So 177 of the domestic relations law, irretrievable breakdown. Next question. At what age can my child choose where he or she wants to live? There's no magic age. 18, you can't even have a custody battle. The person's an adult. 17, 16, it's almost like 18. So if a 16 or 17-year-old kid says, I want to live with mom or dad, assuming there's a valid reason. If they say, I want to live with dad because he allows me to do drugs, that ain't going to fly. But assuming the child is smart enough to say, I'm 16, I want to live with my dad, he understands me, or I want to live with my mom. Right? The older the child is, the more of a say they're going to have. You're not going to ask a 5-year-old where you want to live. They're not going to do that. That doesn't mean they don't speak to a 5-year-old, the attorney for the child. They will talk to the child and they'll say, what's it like with mom? What's it like with dad? When you're bad and you're with mom, what does mom do? And when you misbehave with dad, what does dad do? You get a sense of, like if the kid says, oh, when I'm with mom, it's great, we do this or that. What's it like with Dad? Oh, Dad. You get a sense without even asking the question. Or if the kid says, when I misbehave with Mom, she slaps me. When you misbehave with Dad, he gives me a timeout. The law guardian can kind of figure things out where this kid should go. But with a 14, 15, 16, they have more say. The older they are. But they have to articulate. If a 12-year-old says, I want to live with Dad, why? Because I want to. That might not be good enough. Next question. Can a felony get reduced to a misdemeanor or violation? So if you're charged with a serious crime, let's say, well, murder is the worst, but let's say robbery, burglary, can that case get pled down to a misdemeanor or a violation? The answer is yes. I see that every day. Right? Cases from a felony a lot of times go to a misdemeanor, or a misdemeanor to a viol, or a viol can go to an ACOD, adjournment in contemplation of dismissal. Every case is different. There's a thing called plea bargaining. So the DA might say, I got a really strong case. My plea is I'm not coming off a felony. But instead of 10 years, I'll offer you 5. Or if it's a misdemeanor, and say, instead of jail, I'll give you 3 years probation. Or I'll give you this, I'll give you that. The attorneys, the assistant district attorney and the defense attorney, try to work out a plea bargain. Most cases get pled out. The ones that don't go to trial. And at trial, a judge or jury decide if he's guilty or not guilty. If he's guilty, then he gets sentenced by that judge. If he's not guilty, he walks out of there a free man, never having to go back to court for those particular charges. So a felony can be reduced. That's why it's important to get a good attorney that knows the system, that's been there. Sometimes, like myself, former assistant district attorney. I know the ins and outs of the system. That's the kind of attorney you want to go to at least sit down, have a consultation and say, look, I know I'm in trouble, but what do I got to do to get out of this? Next question. Is there restitution in a criminal case? The answer is yes. So if you commit a crime, let's say you break a window, so you get charged with a crime. The person whose window you broke can certainly sue you. But sometimes it's a lot easier to call the DA and say, that window cost me $200. The DA will say to the defense attorney, we can work out a plea bargain. I just told you about plea bargains. If your client pays that $200 or repairs that, gets that window repaired and pays restitution to the injured party, the person who owned that house owned the window. So he writes a check or gives a check, an escrow check from the attorney for $200, and sometimes the case can go from misdemeanor to a violation or violation to an ACOD because the victim was made whole. Right? You see these a lot in non-violent type cases. You can see them in violent cases as well, but usually it's like, let's say a guy, it's a DWI, driving while intoxicated, and he hits another car, and the other person has a $500 deductible, right? He can be sued, or they can say, look, just cover the other person's deductible, or the other person is out of pocket $1,000, you write a check for $1,000, or your attorney writes it, because usually they want an escrow check. Then that person can get a better deal, and the person who was injured, either monetarily or physically, can be made whole. Next question. What happens if the police don't read me my rights? It's called Miranda, Arizona v. Miranda. We talked about this in the first part of the show. Miranda rights, you've all heard it, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to an attorney. If you cannot afford to be, one will be presented for you. It goes on a little further than that, but that's the Miranda warnings. Usually on a card, and the cop reads from the card, even if he knows it by heart, so he gets it right. Because any mistake in the Miranda warnings could affect that statement coming in. And that statement has to be made freely and voluntarily. Obviously, they can't beat it out of the person. That person has to have been Mirandized, or wasn't in police custody, or let's say the police said, they put you in a cruiser, or they say, sit down and don't move. They have to Mirandize you. It doesn't have to be only under arrest in police custody. And custody could be, you're told to sit down on a curb and not move. You can't move. You're in their custody in a sense. You might be allowed to leave in 5 minutes, but at that point, it's supposed to be Mirandized. If you're not, what happens? People say, oh, the case should be dismissed. He didn't read me my rights. No. The statement might get tossed if the rights weren't read, or if there was some violation of his Miranda rights, but the case can still go forward. So let's say a guy shoots someone, and the police see this, and the police come over and they talk to the guy and they forget to Mirandize him, and he says, yeah, I shot that guy, so what? Can they use that statement? Well, if he should have been Mirandized, the answer is no. But the officer and any other witnesses that saw the shooting can testify. Forensics can be used to prove the case. Let's say they got the guy and he had gunpowder residue on his hand, and they can prove that that was his gun, or he shot the gun. There's a video, there's witnesses. The case can still go on even without that statement. So it might be an important part of the case, but it can still survive. So if you're not Mirandized, tell your attorney, and he can use that information. I once had a Miranda hearing, we call it a Huntley hearing, years ago, and I was able to prove that my client was read his rights, but the person was driving, the officer was driving in a car. My guy had a problem with the language, was in the back seat, really didn't see the guy read them, and he couldn't really understand. The cop was driving on Sunrise Highway. That statement was tossed out. The case proceeded and we got a not guilty verdict. But that statement could have hurt my guy because they said he made a confession. So the cop could get on the stand and say, yes, I arrested Mr. Jones, and when I did that, I Mirandized him. And then he said, like in my cousin Vinny, I shot the clerk. Okay, that can be used. So even if it's, let's say, a weaker case, the jury can hear he made a statement against his own interest. He made a confession. Without a confession, maybe the case is weaker. Next question. How does the attorney get paid in a personal injury matter? Now, in a personal injury matter, let's say it's a car accident case and you're suing for $100,000. You have to go to Supreme Court, unless it's a federal issue. But you go to Supreme Court because, remember, you can't go to county court if it's more than $25,000. You certainly can't go to district court, $15,000. You go to Supreme Court. But how does the attorney get paid? Now, in a criminal case, the attorney gets paid by a retainer. In a family court case, they get paid by a retainer or per appearance. In a divorce case, they generally get paid a retainer up front, and there's an hourly rate, and that eats away the retainer. Or maybe in a criminal case, you might do it per appearance. So they pay a $1,500 retainer, let's say, for 3 court appearances or something like that. Well, each appearance eats away at that retainer. At the end of 3, there might be additional monies due. A personal injury case is very, very different than those other types of cases. Generally, a personal injury matter, the attorney gets 1/3 of the ultimate settlement or award. And if the attorney put forth, let's say, $5,000 of fees, could be expert fees, it could be court fees, he would get that back in the settlement. So you have to have a retainer, a written retainer that would say, I get 1/3 of the award, whether it be by settlement, so it doesn't have to be a trial. I can, a couple of phone calls, send the documents over, their medical records, whatever, to therapy records, to the insurance company or the other attorney, the defendant's attorney, and they could say, okay, this case is worth $100,000. I might say, I want $150. All right, I'll give you $125. Will you take it? And let's say we work it out. I just got my client $125,000, not by a trial, but by a settlement. If the case goes to trial, the jury can make an award of 100, 200, 300, whatever that number is, or 0, the defendant's verdict. But if you get the award, it's still 1/3, no matter how you get it. And so if you got them $90,000, your fee would be 1/3, $30,000. Okay? And that's how you get paid, plus expenses. So if I laid out money, I get that back, and then I get 1/3 of the settlement. The person would get 2/3, and that's how it works. If it's a minor, let's say I'm representing a child, there would have to be an infant compromise. So we go to court, and I bring the child with me, and we have to convince the judge that this is in the child's best interest. Because with an adult, you don't have to do that. The person's over 18, or 18 or over, they can sign a document saying, I want to settle the case, I'll accept $100,000. With a child, you have to do an extra step, an infant comp, because the judge could say, you know what, that child obviously is not old enough to make his own decision or her own decision. And we think that that's not enough. They're never going to say it's too much, but that's not enough. And then if they think it's adequate, the judge then would sign off on it, and the money would be put aside for that child. So when that child gets to be a certain age, 18 or 21 or whatever the case may be, they will then be able to retrieve their money. Quick funny story in the minute and a half we got left. Years ago, I settled a case for a minor. And the money was put in an account for that child, so when she hit the age of 18, she would receive the money. As she got close in age, she had a falling out with her parents. She moved away. So when it became time for the child to get the money, we reached out to the parents, because that's where the child had lived, and the parents did not know the child's whereabouts. So we had a problem, because how do I get the money? I can't send the money to the parents, because now the child's an adult, and there was a falling out. I got to find the individual. So I used Facebook. I said, please contact me. Nothing. Then I put up there a private message, and I said, you got some money coming to you. Reach out to me. The person did. We were able to work it out. They called my office. They got their money. Everybody was happy. In the 30 or so seconds left, I want to thank you for watching the show. If you see, again, Finding Common Ground on either Altice, you subscribe, or if you see it on Facebook, you can like and share to get the word out. I hope the show was informative. Again, next Saturday, channel 115, 10 a.m., you can see another show, and we will be talking about the law. Sometimes we talk about politics, but I think this is a good opportunity for my audience to watch the show, and I hope you'll learn something. That's what it is. You're not going to memorize everything I said, but if you come away with a portion of it, I think that's good. You have a good day.